Now, let us know the relations of principal and agent with a third person. The agent is entering the contract with the third party on behalf of the principal, right? So there must be a relation. There is a relation between principal and the third person and the agent and the third person. Let us know when does the liability of the principal arises and when does the liability of the agent arises. So under this we are discussing the two important things, that is the agent's liability and the principal's liability. Liability, first is the liability of the principal. What is the liability of the principal? That is dealt under section 226, which gives effect of agent on contracts with third party. Of agency, sorry, this is agency. Of agency on third party. What is the effect of this agency? Agency on contracts with a third party. What is the effect? So we know that from the very basics we are getting to know that for whatever the acts done by the agent, principal is bound for those acts. And whatever the obligations that are arising from the contracts entered by the agent, the principal is bound by those obligations. So it is in the same manner as if the principal himself has entered the contract. Though the agent is entering, still it comes into force as if the principal is entering. He is making such contracts. So under such contracts, we also got to know what are the liabilities. We were discussing right from the modes how the principal becomes liable, when does the agent become liable. So this principal, he can, if the agent has not been authorized and if he is entering any contract, then the principal can ratify it if it is favorable to him. Even by as there is one of the mode in which the agency can be created, that is through estoppel. We studied the different modes of creation of agency. So even though not authorized by the principal, in case if the agent enters, it is up to the principal to become liable for that contract. It is up to him. It is his choice. It is at his option. So there and all we have seen how, where and when the principal becomes liable. We also saw that implied and express mode, through that giving the actual authority, he is bound by the acts of the agent. We also saw the other modes where he becomes liable. Now here, in particular, we'll see the situation where principal's liability arises. There are situations where the principal's liability arises. We are going to study we have three situations basically, and we will study each of the situation in detail. The first one is when the agent exceeds his authority. The first point is when the agent exceeds his authority. And the second point where the liability of the principal arises is when the agent receives notice on principal's behalf. In case if he receives on behalf of principal any notice, how does the principal become liable? The third one is when agent commits any fraud or some other wrong against the third person. Remember we are talking from the third person's perspective. So if at all, how the liability arises from the agent entering the contract with a third party for his authorized acts as well as unauthorized acts from his, whatever the agent has got certain authority, right? And still if he is exceeding his authority, without authority he is entering certain contracts. So how does the principal liable? So now we'll go to the first one. When the agent exceeds the authority, the first point is when the agent exceeds the authority. What do you mean when the agent exceeds the authority? So, while entering the contract of agency between the principal and the agent, they make an agreement saying that you are authorized to do only this particular business transaction, and your extent or your limit of being an agent is only so much. And the agent duty is to follow the principal's direction and to act in a way which he is authorized. For whatever the powers is given by the principal, he has to utilize it and act in whatever the direction given by the principal. And for this, whatever he is doing within his powers, for that the agent is liable to the third party and also the agent. What if the agent exceeds his limit or exceeds his authority? He's been authorized for certain transaction, and if he is exceeding his authority, what to do? Sometimes it happens that under a business transaction, there is some part of it which is authorized by the principal, and there is other part which is not authorized by the principal. In such cases, what should the principal do? So first question was, what to do when the agent exceeds his authority. The second part was, in that business transaction, there is certain part which is authorized and there is other part which is not authorized. Then what to do? So now let us try to know that. So first one is position when the authorized and unauthorized acts are separable. What is the position when the acts, that is authorized and unauthorized, can be separated? That's given under section 227 of Indian Contract Act. It says that if there's a business transaction in which there are both the acts, that is authorized as well as unauthorized, done by the agent, and if it can be separated, when separated, then I'll proceed. Then when they are separated, the acts which are authorized, for that the principal can become liable, and for the unauthorized he cannot be liable. Clear with this? That is what your section 227 says. So it explains the position of the acts done by the agent within the authority, and thus outside the authority, whatever it is outside, that can be separated. It is separated. It is separable. So it states that only whatever is within the authority is binding the principal as well as the agent also, with the third party. Clear with this? Unauthorized? No, he never becomes liable. Now let's take an example. How do you separate this, ma'am? You must be having a question. We'll take an example for this. There is a person A who is the owner of a ship, and there are certain cargoes also in that. He calls his agent B and says, B, you please go and get an insurance done for the ship. He says only ship for rupees 4,000. This person B is authorized only for making an insurance for the ship of 4,000 rupees. He goes, he takes an insurance for a ship worth 4,000 rupees, and also plus he'll take for certain amount for cargo also. Now the question is whether the principal becomes liable for whatever the insurance he has taken for the cargo also. His instructions were very clear. You make insurance only for the ship for rupees 4,000, but the agent has insured even the cargoes. And this transaction can be separated. For ship it is 4,000 and there is other amount which is for cargo that is unauthorized. So now, as per section 227, the principal becomes only liable for the first authorized portion, that is insurance for the ship, under section 227 of Indian Contract Act. Remember this, he has to pay the premium for only the insurance policy taken for the ship worth 4,000 rupees. Now we have a case law for this, Hamad versus Muhammad Kuni. What happens in this case is, an agent is authorized by giving a power of attorney. The principal says to the agent that you sell half right over certain property. There is a property and the principal says you sell only half. So then he entered into an agreement with the purchaser, he is a plaintiff here, to sell the entire property. What is authorized by the principal? Only half property. But this agent sells the entire property. So here in this case, do you think the authorized and unauthorized portion can be separated? Is it separable? Yes, it is separable. He says sell only half portion. So now it was held in the court that specific performance of that half portion of a property could be claimed by the purchaser under specific relief act, in respect of which the authority was given by the principal to the agent, that is only the half property, half right, whatever was told by the agent, the principal. So the third party gets only the half of the property. Clear with this? How does the liability, how is the principal liable for this, for authorized and unauthorized works of agent? So we saw the position when they are separable, when they can be separated. Now what is the position when they are inseparable, when they cannot be separated? What to do then? That's given under section 228 of Indian Contract Act. It says that where an agent does a work that more than what is he authorized to do, and it cannot be separated, the principal is not bound for that particular transaction. Clear with this? It says that simple. He is not bound for the transaction only. When you can't separate it, how can you make him liable? He is not liable to this particular contract itself. Now, let's know the principal's liability towards the third parties. The second one is the principal's liability for notice to agent. It is given under section 229. It says that, the section 229 says that any notice given or any information obtained by the agent in the course of business, during the business transaction, has between the principal and the third party have the same legal consequences as if it is given to or obtained by the principal. What it says, in short, if there is any notice given, any notice can be given, or if any information is obtained by an agent, when during the business transaction between the principal and the third party, that the information or notice shall have the same legal consequences, even the agent has got it, that will have the same legal consequences as if it is obtained by the principal or it is given to the principal itself. To the third party and the principal, they both are bound in such a way. Same legal consequences as if the principal has given the information or he has obtained such information if the agent has obtained it. That is what your section 229 says. Let's go for an illustration and let's understand it in a more better way. It says that Now there's a person B who's a principal. He has employed A, his agent, to buy certain goods from C. This person C seems to be an apparent owner. He is not actually the owner. He just seems, he shows off that he is an owner of certain goods. Considering him as an owner, the agent enters into a contract with him for a sale of goods. Then later, A is the agent. He learns that no, this person C is not the real owner, and there's a person D who is the real owner of these goods. But the B, who is D, the principal, he is ignorant about this fact. Now what is the consequences? B is not entitled to set off a debt which he is owing to him from C against the price of goods. Now he cannot set off those debt which is owing from C, which he is supposed to get from C. Clear with this? That is what it says under section 229. Now let's go to the third liability, the last one, that is principal's liability for agents, fraud, misrepresentation and tort. That's given under section 258. It's a very interesting topic and you have also learnt about this in your law of torts. What it says is, misrepresentation made or any fraud committed by the agent, if while acting in the course of a business, has the same effect on the agreement made by the agent as if the misrepresentation or fraud are committed by the principal. The very first point in this, it says that if there is any fraud or misrepresentation done by the agent during the course of business, it has the same effect as if the principal has done it. So principal becomes liable for agent's fraud or misrepresentation or any of the tortious act. Point number 2. There is one more point to be remembered. But if the misrepresentation made or frauds committed by an agent does not fall under the authority which is given by the principal. So agent has done certain fraud and misrepresentation which does not come under the authority given by the principal. Then do you think the agent is liable, the principal is liable for this? No, the principal won't be liable. Do remember, if within the authority, if he is committing any of these acts, then the principal is liable, and if the acts are committed which does not come under the authority of the agent, then the agent won't be liable for this. Now let's take an illustration for this and try to understand better. There is a person here who is the agent of B, and there are some goods which need to be sold. So this person, the agent, he approaches C and he makes him believe. He induces C in such a way that he is making misrepresentation and he is also selling the goods for which he is not authorized by B, that is the principal. So under this, the contract becomes voidable as between B and C at the option of C. Who is C? C is a person who that is a third party who is buying the goods, considering it to be he is taking a good faith and he is buying it. Now who is B? B is the principal. Agent has misrepresented and he has exceeded his authority. He was authorized to sell only these particular goods, but he also sells other goods also, which he was not authorized. The principal did not give permission to sell those goods also. So he sold it and C has taken in a good faith. Now this contract becomes voidable and it is at the option of the principal, between the principal and the third party, and the third party has an option for this. He can accept it or he can cancel this particular contract. Clear with this? So this is the example for principal's liability for agent's fraud, misrepresentation or tort. Now we'll move on to a very next interesting topic, that is vicarious liability of the principal. You would have studied this earlier also. Vicarious liability means for the acts of the agent, the principal is held liable. Simple. For any acts within the business transaction, if that is during the course of business transactions. So here, before going into the case laws and all, we'll just see one maxim. This is a quite interesting maxim. Qui facit per alium facit per se. It means that this is an important maxim which you also need to mention. It means that the act of agent is the act of the principal. So whatever the agent is doing, it becomes the act of the principal. The principal is bound by the acts of the agent. If he is authorized to do so, then the principal becomes liable for his acts. Now, to understand this more clearly, you will go and see some case laws. So you will be able to understand this in better way. Case law: Lloyd versus Gray, Smith and Company. We have studied this case. It's a very interesting as well as important case in a contract. So under this, what happens? I'll just tell you the brief facts of the case. This is for how the principal becomes liable for the acts of the agent. This case gives a wonderful explanation. What happened? There is a lady, Mrs. Lloyd, who owned 2 cottages. She had 2 cottages in her name, but she was not satisfied with the income from it, so she approaches Gray, Smith and Company. It is a firm of solicitors to consult about the matters relating to the property. There, she was attended by the firm's managing clerk, and he says that he was one more point. He was acting as the firm's agent there, and he gives her the suggestion to sell it so that it will be a better option for her to get more income. This lady agrees, Mrs. Lloyd agrees, and she signs 2 documents thinking that it is a sale deed. But that managing clerk gets the paper signed, and it is not a sale deed, it is a gift deed in his personal name. In his name. So then this managing clerk, after getting the gift deed from her, he disposes of the property, that is the cottages, and he misappropriates the fund. So here it was, he had acted without the principal's knowledge and solely for his personal gain. Right? Still, it was held in this case that agent is acting in the course of business. So principal was held liable in this case. This is a very famous case. Hope you would remember this. Lloyd versus Gray, Smith and Company. How the managing clerk has misappropriated the funds being a firm's agent. Clear? Now let's move on to the next case law, that is National Bank of Lahore versus Sohanlal. What happens in this case is, we have already studied this case under the contract of bailment. There the plaintiff had rented a locker for the deposit of jewelry and other valuables. What did we study under bailment, contract of bailment? For a locker, under locker, the banker does not, there is no relationship of bailer and bailee existing between them, because the banker does not know what are the contents in the locker. If there is anything also, he doesn't know, and if at all there is nothing in the locker also, he is not aware of it. Clear? So coming back to this case, so the plaintiff here rented a locker. He rented the locker for depositing jewelry and other valuables. Later, he finds that after some days, when he comes and opens the locker, he finds that the jewelries are missing and also valuables are missing. Then it is found out that the manager had filed the waiver of the locks and of the renter's keys. I mean the renter, that is the person who's taking a locker, has got a key, that is customer's key, and the banker would also have a key. So only when the two keys are being operated, then only the locker opens. Anyhow, this manager had with him the keys. So he got the other key of the customers also done, and he opened the locker and he has taken the jewels and misappropriated it. So here in this case, it was held that even without the customer's key also, the locker could be opened. So the banker becomes the bailee in this case, and they are liable to compensate. And also the agency, they established the relationship of agency between the bank and the manager. The manager is working as an agent of the bank. So the bank has to compensate for the losses which the plaintiff incurred. So 2 points were established. One is relevant to your contract of payment, other one is your agency relationship. In both the ways, they were held liable and to compensate for the plaintiff. I hope you're clear with this. There are other cases also pertaining to vicarious liability. There is one more case, that is M.N. Shankar versus Maharashtra State Board of Secondary and Higher Secondary Education. In this case, there were 30 students who submitted their application plus fees to the headmaster of a school for their board exams, and this headmaster forwarded through a clerk of the school the fees and application. He gave it to the clerk. That clerk misappropriated the funds. He took the funds for himself and did not give the application to the board. Now a case was filed regarding this, that how could even though the kids had, I mean the school students had given the money for the whatever is relating to examination, and they've also given the application, how could they not be allowed to write the exam? It was held that the said school was recognized by the board for accepting the fees. It was the said school was recognized, yes, you can collect the fees on behalf of us, and also the application. Therefore, it was the agent of the board. It is acting on behalf of the board. Therefore, this section 238 was applied there, and it said that you should allow that students to write the examination as well as declare the result, and you are the principal and they are the agent. Who is the agent? The school is the agent and the board becomes the principal. So the principal was held liable. The board was held liable in this case. Clear with this? There is also one more case law wherein it is State Bank of India versus Devi. In this case, the plaintiff husband gave some check and cash to his friend. He gives this to his friend, who is that person, that friend is an employee in the defendant bank, for depositing it in the plaintiff. Plaintiff has got an account. He says that please deposit it into my account. The amount plus check were given in his personal capacity, in a private capacity. At that time when he is giving to his friend, he did not give him as an agent of that bank, or he was not an employee of the bank. It was a private private transaction, that is in private capacity. The check plus the cash is given, though he is an employee of a bank, but still at that moment he was not representing the bank. See, once you give your check or when you deposit your cash, you get a receipt for that, which he did not get. So thereby it was given in the personal capacity there, and the friend, or that is that employee or the friend, he misappropriated. So it was held that bank was not liable. This is one case where you can find where the principal does not become liable. Though the employee is an agent of the bank, still the bank was not liable because of the personal capacity of the friend or employee. It was given in his personal capacity. Do remember this. So, these are some of the case laws for your vicarious liability of the principal, and this is your liability of the principal towards the third person. Clear with this? I'll just revise this again. So, the first one is, if the agent exceeds his authority, then what happens? Then the second one is principal's liability for notice to agent. Then principal's liability for agent's fraud, misrepresentation of fraud. Under that you have something called vicarious liability of the principal. Therein you have this case laws which clearly explains when does the principal become liable. Now let's know how the agent becomes personally liable. The previous topic we studied about the liability of the principal. Now let's know personal liability of the agent. Now you may have this question in mind. All this time I was telling that for the acts of the agent, the principal becomes liable. Principal authorizes the agent certain work, and the agent has to do that work. When he does it, when he enters into a contract with other parties, it becomes binding on the principal, and the agent is no way liable. If there is any loss also, the agent becomes liable. For any act of the agent, the principal becomes liable. Now we are saying that personal liability of the agent. Does the agent incur any personal liability? Section 230 of Indian Contract Act says that agent cannot personally enforce nor be bound by contracts on behalf of principal. It says that agent can never become liable if he is acting on behalf of the principal in simple. But also from this section, it gives certain circumstances. It is presumed that if the agent has consented to be personally liable, then he becomes personally liable for those transactions or contracts. And what are those situations under which he becomes liable? Point number 1. Agent acts on behalf of foreign principal. If he is acting on behalf of a foreign principal, he becomes liable. The second one is agent acting for undisclosed principal. If he is not disclosing the name of the principal, he becomes liable. The third one is when principal disclosed cannot be sued. He is disclosing it and still he cannot be sued. Yes, this is also dealt, and we will see how it takes place. How does the agent become liable? The first situation is when there is a contract for agent's personal liability. The agent is making a contract that he will be personally liable. Then he becomes liable. Then agent making breach of some legal obligations. He is making certain breach of legal obligation, contractual obligations or statutory obligations which he needed to follow. Then he becomes personally liable. Then the last one is liability of pretended agent. Who is this pretended agent? We'll see one by one. The first one is agent acts on behalf of a foreign principal. Under this, it is said that when a contract is made by an agent for any sale or purchase, and that particular principal is in foreign country, he is in foreign place or in abroad, then at that time the agent becomes personally liable. Remember this, where there is a contract entered by the agent on behalf of a principal who is residing in foreign or abroad. If there is any contract for sale or purchase, then the agent becomes personally liable for that. So this is one situation where you can say that he is undertaking the responsibility. The presumption here is basically that yes, the agent by becoming an agent to a person who's residing in foreign, he is undertaking the responsibility that he will be personally liable for this. In case he does not want to become liable. So, what to do? That is, when he is entering the contract or doing any transaction with a third party on behalf of principal who is residing in foreign country, he can clearly say that no, he does not want to become personally liable on behalf of his principal. He does not want to become personally liable because he is acting for the principal. He can get these things entered in the contract itself. By doing so, he does not become personally liable. There is a wonderful, example for this. In this case law, Midland Overseas versus CMBT Thana. What happens in this case is, it's quite interesting. There, in this case, it was basically held by the court that in order to support this view, it is held that if there is circumstances which indicate that agent is acting on behalf of a principal who is residing abroad but does not undertake the personal liability, then the agent's personal liability does not arise at all. So, this following case judgment gives you that when exactly the agent does not become personally liable in the business transactions. So, if he says that, he voluntarily says that no, I don't want to take the responsibility, then he does not become personally liable. That is what is given in this case. So, agents act on behalf of the foreign principal. He does not come under, he becomes personally liable unless he has a contract stating that he does not want to become a liable personally. The second one is agent acting for undisclosed principal. We had discussed this. It was a duty of the agent not to enter into a contract in his own account. From his own name, he should not enter any accounts. He has to always clearly say that he is the agent working on behalf of his principal. So now the question is, if at all he enters into a contract and he is not disclosing it, that he is the agent of this person, what happens? How can he bind the contract with a third person? So it says that when the principal is undisclosed, the liability under section 230 of the agent and the principal cannot be sued. It clearly says that you cannot sue the principal. For agents, any acts you cannot sue in case if his name is undisclosed. Clear with this? The next point is when principal disclosed cannot be sued. Okay, in the previous point we discussed that the principal is not disclosed. Principal's name is not disclosed. Still, you made the agent personally liable. Here, in this case, in this point, you're disclosing the principal. Why is he not liable? Why can't you sue the principal then? Why are you making the agent personally liable? This comes under section 230 clause 3 of Indian Contract Act. It says that when the person who is entering the contract is incompetent to the contract, entering the contract, that is in case if he is a minor, the principal is a minor, then what happens? We've discussed this. It says that if he is a minor, then the minor, that is the principal, does not become liable. He cannot be sued. So that time the agent becomes personally liable to the third party for the business transaction and not the minor. So it is very important that the principal has to be competent to the contract. In case if he is not competent to the contract, then he cannot be sued. plus you can even take the example of companies. A company which is not formed yet, and there is some loan taken on behalf of the company. Now, can the company which is non-existent, has taken some loan, has entered into a transaction, can you make it liable? No, you can't make the company liable. The person who have taken the loan before the company come into existence, they can be made liable. Clear with this? Now we have a case law for this, that is Union of India versus Chinoy, Chablani and Company. What happens in this case is the Union of India is actually the Mineral and Metal Corporation of India, who are represented as Union of India here. That is Mineral and Metal Corporation of India. This Mineral and Metal Corporation of India, they entered into a contract with Black Sea Steamship Company, that is at USSR. And this contract is entered for some fertilizers which has to be shipped to India. These people, Shinoy, they are the steam agents. Steamer's agent. They are the steamer's agent. That is the Black Sea steamers, they are the agent. Who were aiding in discharging the above consignments which were entered. The contract which was entered, for that they were discharging those consignments. When it was shipped to India, it was found that certain bags were torn and cut, and it was not in a good condition. So now, what does this people do? That is the Union of India, they file a case against the agents. That is this people, Chinoy and Company. They file a case against this people for the loss. Also, they contend that the shipping company was in USSR and they could not sue them because it is not in India. That's why we are filing a case against this agent, steamer's agent. It was held by the court that agent not liable since the contract was directly entered by the principal and the third party. Though they were the agents, they never came in between to negotiate. That is why the agent did not know anything. They just helped in discharging the consignment from one place to another. That's it. So the actual contract was between the Union of India and the steamship company, which was in other country. So from this, we can also know that there is one more point to be noted here is if the third party and the principal themselves directly enter the contract, then the agent does not become liable, personally liable. This was got from this particular case. So the principal, though disclosed, cannot be sued in case if they are entering, that the principal and the third party is entering the contract directly, then the agent won't be liable. This provision is applicable, this particular provision is applicable when the agent enters into a contract on behalf of the principal and he discloses the name of the principal, but the principal cannot be sued. That is one point. So this provision is applicable only when the agent is entering the contract. If the principal himself, though he is a minor, if he enters the contract with third party, the agent is not personally liable. Clear with this point? We'll proceed to the next point. That is, when there is a contract for agent's personal liability. And when you read the section 230 of Indian Contract Act, it begins with the word in the absence of any contract to that effect. It says that if there is any contract indicating, if it indicates that the agent is taking up the personal liability, then he can be made liable for that. Clear with this? It says that it clearly gives, if he during the making of contract, if he says that yes, I will take up the responsibility, I will be personally liable, then he becomes liable. There is one case law for this which can be an example for this, that is Alliance Mills versus India Cement Limited. There is this agent, he enters the contract on for the purchase of certain goods. He enters in his own name, describing that yes, I am only the purchaser. He did not disclose that he is acting as an agent on behalf of another person. He says that I am the purchaser and I am buying these goods. So now it itself indicates that he is taking the obligation on himself to pay for the third party. Though he is an agent, he should have disclosed, which he does not do. And they enter into a contract. Now he becomes liable. From this particular thing only, you can make out that there is a contract that agent is taking the personal liability on him. Clear? We'll move on to the next one. Agent making breach of some legal obligations. If the agent is making some, when there is some requirement of legal obligations to be followed, such as contractual obligations or statutory obligations, there are obligations which the agent has to follow. If he does not follow that, then he renders himself personally liable for the breach of such obligation. That is, he becomes liable for that. He was authorized by the principal. That means that he is also liable to follow. He has an obligation to follow certain legal things, right? If at all he does not follow, then he becomes personally liable. Similarly, when the agent commits any tort against the third party, that also creates personal liability in consequences of his actions. So whatever he has committed, he becomes personally liable. Now, we'll take a case law for this, that is Nepal Food Corporation versus UP Import and Export Limited. This is a simple case which gives you makes you understand this point here. There's a plaintiff who loaded a rice in a vessel for carriage by sea. It has to be given from one country to another country. It has to be sent. So he loads it in a vessel by sea. Whenever something is loaded or unloaded, there is a receipt given for that. The agent of the owner of the ship. There is a ship and there is an agent appointed by the ship. It is his duty that he has to issue a bill of lading. Bill of lading is basically, in simple terms, saying that yes, there are some goods loaded inside, and when it's unloading also, they're going to mention. That is called bill of lading. It's in simple, which is a contractual as well as a statutory obligation that they have to mention it. It is one of the proof. It is one of the document which states that yes, the goods have been loaded. This agent, he does not issue that bill of lading. So now there was a case. Since maybe there is some problem with that, problem caused or damage caused to the defendant, so they filed a case. It was held that agent not only committed the breach of contractual duties but also committed a tort of conversion. And therefore, agent plus the principal was liable for the damage due to the delay in issue of bill of lading. Because of the bill of lading, maybe their goods, the defendant did not get the goods on time. There was some problem. Therefore, the principal also, in this case, the principal plus agent was held liable, and the agent was liable in his personal capacity to the principal because for making a breach of some legal obligations. Then the last point is liability of pretended agent. What is this liability of pretended agent? Pretended agent means though he does not have the authority, he is not authorized by the principal, still he is doing certain works on behalf of principal in the principal's account, from the principal's account, So it says that a person untruly representing himself to be an authorized agent and thereby inducing the third party to deal with him or entering a contract with him, the agent is liable for this particular act. And in case if the principal says that okay, my agent has done something which is unauthorized, I'll ratify. If the principal wants to ratify it, then the principal has to compensate for the losses. If at all the principal does not ratify the particular contract, then the agent becomes liable in his personal capacity, that is pretended agent. Though he is not authorized, he is doing certain acts which seems that he is authorized for that. So, we'll take an illustration for this for understanding better. There are two persons, A and B, who are the directors of the company. They borrowed certain loan from person D for the company. But as per the memorandum of association, they were not supposed to do it. So now what happens? D was unable to recover and he sued the directors. They did not give them, so he sued the directors. So do you think the company was liable? Who were liable? Yes, the directors were liable since they were not authorized. They pretended as if they are agents, authorized agents to take loan, and they have taken loan. That is why they become liable in their personal capacity. We can have one more case law here, that is Krishna Kant versus Dilip Kumar. Here, the plaintiff had purchased certain land belonging to defendant number 1. This defendant number 1 was staying in US. And there was one more defendant number 2 who said that we have the power of attorney of this land which is given by defendant number 1 and that is why they are selling the land. The plaintiff in good faith, they said that they agreed to buy the land. This defendant number 2 who pretended to be the agents of defendant number 1, they also sold this land to others. Now, after knowing this, there was a case filed. He said that defendant number 2 that the sale date will be ready and I'll get it signed. But they said no, the defendant number 1 did not agree, who were there in US. Now the case was filed for making them to enter into the sale deed by specific performance. It was held that the defendant number 2, that is who were pretended agents, did not have any sort of contract between the defendant number 1. There was no privity of contract between the owner and the agent at all. They were unaware of this. And also the defendant number were not entitled for specific performance. The defendant number 2 had no implied or even the ostensible, that is apparently they were not the people who had power of attorney, special power of attorney to execute the deed also, to execute the sale also, to execute the sale. So they were held to be liable to make compensation to the plaintiff who were liable for any damages which is caused by the defendant number 2. Remember, defendant number 2 were the pretended agents. Now let's come to the last part of agency, that is termination of agency. We learned about how to create the agency, what are the different modes of creation of agency, what are the rights, duties of the agent and the principal, and the principal's liability, and also when does the agent's personal liability come into force. Now the last part of agency is termination. How do you terminate this agency? So there are certain modes which are discussed from section 201 to 210 about this termination of agency. By terminating the agency, the principal won't be liable for the agent's acts. The agent cannot enter any contract on behalf of the principal. So termination is basically closing it. They are no more liable to each other. There is no obligation on each other also. So what are the modes? Now let's see what are the modes. There are basically 5 modes how you can terminate the agency. The first one is revocation of agent's authority. The first mode is you're either revoking means basically you're withdrawing or you're cancelling the agent's authority. The principal withdrawing the agent's authority. Then the renunciation by agent. The agent is giving up. He does not want to, he is renouncing. He does not further want to be an agent. So he is giving up. Then completion of business of agency. So for whatever the purpose they have entered and that is completed, entered into a contract of agency, and if it is completed, then the agency comes to an end. The fourth one is death or insanity of principal or agent. If death of the principal or death of the agent, or if the principal becomes insane or if the agent becomes insane, then there is termination of agency. Then insolvency of principal. If the principal become insolvent, bankrupt, then also there is termination of agency. So these are the modes which are given under Indian Contract Act for terminating the agency. Now for the first one, revocation of agent's authority. There are certain rules which are given under Indian Contract Act for revoking it. What are those? Point number 1, express or implied, given under section 207. It says that the revocation may be express or implied. You can give it in express, you can give it may be express, or by the action it can be revoked. That's the first point. No revocation of agency when an agent has interest in subject matter. This is quite interesting. That's given under section 202. No revocation of agency when agent has interest in subject matter. How the agent has interest in subject matter? Agent should not have any interest. How is it? So it says that as per section 202, there can be no revocation of agency when an agent has an interest in a subject matter. So there can be no revocation. That's basically given in section 202. Always remember, when the authority of an agent is coupled with the interest, there is an interest with his duty, that authority conferred on agent cannot be revoked to prejudice the interest of agent. So interest is having certain, what do you say, certain interest in, he has got certain things which he has to recover it. He has got, maybe he will be benefited from that particular transaction, and that is within his authority also. How is it possible? Now let's take an example for this, and let's try to understand this in a better way. So A has given authority to B. He says to B that, see, I am having a land. You please sell this land. And by whatever sales proceed you get it, you keep it to yourself out of the land. He has certain debt which is due, or maybe there is some amount due to be paid to the agent from principal side. He says that you sell this land and whatever the proceeds you get, you please keep it to yourself. It is his rightfully, the agent had to get that money. So now, as per this, when he says that and when sales proceeds are over, he cannot ask that back, or he cannot revoke it, or he cannot terminate the contract also. So in case, I can give you another example also. Now, A consigns to B 100 bales of cotton. This person B is an agent. He says that he gives certain advances for those cottons. He told you, please give it to me itself and I'll give you certain advance. And whatever the 100 bales he's got, he sells it. And he takes a certain money for whatever advance he has paid, that he has taken. The B has taken it. Now, A cannot revoke it. He cannot say that whatever the proceeds you got from the sale of 100 bales of cotton, the entire thing you have to give it to me. No. What was due to B has to be cleared off. So, he initially says, they enter into this agreement that you take this 100 bales, sell it, whatever amount you get, you keep it for yourself since you have given me certain advance. So, the B is having an interest in this particular matter, right? There's a interest in the subject matter, that is the sale of cotton bales, he has to get some money. Now A can never revoke this or terminate this contract. Clear with this? So if the authority of the agent is coupled with interest, then the principal cannot revoke it to and cannot prejudice the interest of the agent. Clear? How his interest in the subject matter cannot be revoked. We'll move on to the next point. Revocation possible before the authority has been exercised. It says that the revocation is possible before the authority has been exercised. So it means that before there is any sale or purchase which is authorized to the agent, before he does it, the revocation is possible. Now the agent is appointed to do particular business transaction. Clear? So now before he makes that business transaction, before he enters into that business transaction, before he entering, then it can be revoked. Then the principal has an authority to revoke it. He can cancel it or say stop, don't proceed further. In case if he has entered, agent has already entered, then the revocation is not possible. So it binds the principal. But if it is before he is entering, then it does not bind the principal. Then there is one more point. Revocation when authority has been partly exercised. When a part of the transaction is done. What to do? That also says that under section 204, principal cannot revoke the authority in case of partly done also. That's given under section 204, and this revocation possible before the authority is given under section 203. The next point is principal to compensate for premature revocation without giving any due notice or without giving justification. That's given under section 205. What is this premature revocation? Now the principal and agent have entered into a contract for some to do some sale, and it is for a period of 1 year. Now this principal, before doing it only, he says that no, I don't want to enter into this contract. I don't want this contract of agency. I am revoking this. So that forms a premature revocation. That is before the time only, or before the business transaction, he has cancelled it, revoked it. So that's a premature revocation, and he is not giving any justification also for that. In that case, he has to compensate to whom? Principal has to compensate to the agent, because agent in good faith is acting for the principal. So now it is his duty to compensate, the principal's duty to compensate the agent. That's given under section 205. Now the fifth point is principal to give reasonable notice of revocation. That's given under section 206. So from the previous point of view, we got to know that in case if he is revoking, he cannot revoke all of a sudden. He has to give a reasonable notice. He has to give certain time. He has to say, he has to give proper justification why he is revoking it. And also time. So, by giving that, principal to give the reasonable notice is his duty under section 206. We have a simple case law for that where we can understand how reasonable notice is very much required. It is in this case in Re Mrs. Om Prakash Pariwal, Pariwal. Here the petitioner he is appointed as a storing agent of Food Corporation of India. So when he was appointed as a store manager, store agent, he invests a huge amount for having the stores and also making arrangements to take reasonable care for that. And he also engages certain workmen for that also. So he has spent for storing, for employing and all. Now this Food Corporation of India, they don't give any notice and they terminate this agency. They say that we don't want to have this agency. And this case goes to the court. It was held in the court that there should be reasonable notice given to the petitioner with justification, and therefore whatever the FTI gives notice, without any notice they have terminated, that is not valid. It is not correct. Clear with this? Next, termination of agency, sub-agents, what happened to them? It's given under section 210. It says that who is a sub-agent? We have discussed this. Sub-agent is a person who is appointed by the agent. He works under the agent, right? So in case the agency itself is terminated, what happens to the sub-agent? Even he is also terminated. So termination, if the agency is not in existence, the sub-agent also does not come into existence picture at all. So that's given under section 210. Then agent's duty. What is the agent's duty on termination of agency by principal's death or insanity? What happens? How is he going to discharge its duty? It's given under section 209. It says that agent is bound to take on behalf of the representatives all reasonable steps for protection and preservation of interest that is entrusted to him. Whatever was entrusted to him, he has to protect it and take care of it properly. When the principal was alive, what was entrusted to him, the authority entrusted, that should be carefully protected and taken care of on behalf of the representatives. Clear? That's given under your section 209 of Indian Contract Act. Now, last part is time when agent's termination becomes effective. When does the termination of agency becomes effective? It gives us two cases when it takes effect. That is, the termination of agency takes effect. Number one, it takes effect against the agent when the fact of termination becomes known to the agent. When the agent gets to know that he is no more an agent, then it comes into effect. Second, it takes into effect against the third person when it comes to know to them, when they come to know that this person is no more an agent working on behalf of this particular principal, then he is no more an agent. So it is the time when it becomes effective is against the agent. It is when he knows it, and against the third person when the third person gets information that he is no more an agent. Clear with this? So we have an example for this. Now what happens? B directs A to sell certain goods, and B also says that you sell these goods and take 10% or 5% of commission. So then this A sells the goods to certain person C, and he obtains 100 rupees from that. Later on, this person B, he revokes the contract. Now A is, the particular sale is binding on the agent only to the extent of 5 rupees. That is the commission. He can take the commission and further he cannot make any sales. Clear with this? I think you're clear with this example. The principal has told the agent to take, you sell this particular products and you get whatever the commission you get, 5% you keep it for yourself. And later on the principal revokes this contract. By that time agent comes to know he has already sold 100 rupees worth item. Now he is only he can take, his entitled for only the commission up to the 5%, that is 5 rupees from that particular contract, and further he cannot do anything. Till he got the notice, he has already sold, so he is only entitled to take that much amount. Clear? Next one is renunciation. We were talking about the renunciation. Renouncing by the agent. How can he do that? Section 206 gives us that he has to give a notice, either implied or express. That is given, the implied or express is given under section 207. Loss by the premature renunciation to the principal. If the agent, he is renouncing, he says, I don't want to be the agent further. And if he gives up it, then the agent here has to compensate for the principal. What are the things we have learned, or what are the synopsis? The first one was, we learnt about what is agency, who are the parties to the agency, how do you establish the agency relationship. The next part which we saw was different kinds of agents. Who are the different kinds of agents? Auctioneers, factors, brokers and delicate agents. After dealing with the kinds of agents, we saw some important features of contract of agency given under section 183, 184 and 185. That the principal should be competent to the contract which is given in section 183. The agent may not be competent to contract under section 184, and no consideration is necessary to create an agency under section 185. Then we saw the modes of creating an agency. That is, principal giving the actual authority, either expressly or impliedly. Then agent's authority in case of emergency. Principal bound by estoppel and holding out. Then principal bound by ratification, and we also saw the essentials of valid essentials of ratification from section 196 to 200. Then we also saw the agency in case of husband and wife relationship. Then we went on to the duties of the agent. Under that we also saw sub-agents and substitution agents also, and how is the responsibility towards the principal. We also saw the rights of agents and the duties of principal. Then we saw the relationship of principal and the agent with the third persons. And finally, we saw how the agency comes to an end, that is termination of agency from section 201 to 210. Different modes, how the agency comes to an end. From this, I am concluding the chapter on agency. Thank you.